Missouri has a landlord-friendly breaking lease framework with a duty to mitigate established through case law and some local variations in Kansas City and St. Louis. The governing law includes Missouri's landlord-tenant statutes, found in Missouri Revised Statutes Chapter 441, along with general contract principles. If you're a landlord or tenant in Missouri, the state provides a basic framework while giving landlords broad discretion, though local ordinances in the two major cities may add requirements. Let's start with the landlord's duty to mitigate damages. Missouri courts have established the landlord's duty to mitigate through case law. When a tenant breaks a lease and vacates, the landlord must make reasonable efforts to re-rent the unit. The landlord cannot simply leave the unit vacant and collect the full remaining rent from the departing tenant. The landlord must take reasonable steps: advertising, showing the unit, and accepting qualified applicants. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced. Missouri's mitigation duty is based on case law rather than a detailed statute, which means courts evaluate reasonableness on the specific facts. The local market, property condition, and landlord's typical practices all factor into the analysis. Early termination clauses are generally enforceable in Missouri. The state does not cap early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable under Missouri's contract law principles. Military members have the right to break a lease under the SCRA. Fort Leonard Wood in central Missouri generates significant military rental demand. Whiteman Air Force Base near Knob Noster generates demand in the Warrensburg-Sedalia area. Fort Leavenworth, across the border in Kansas but serving the KC Metro, generates demand on the Missouri side. SCRA terminations are regular in these military communities. Missouri has enacted protections for victims of domestic violence that allow early lease termination. Under Missouri Revised Statutes Section 441-920, a tenant who is a victim of domestic violence, sexual assault, or stalking can terminate the lease by providing written notice and documentation, including a valid order of protection or a police report. The tenant must provide at least 30 days' notice. The tenant is responsible for rent through the termination date but not the remaining term. Tenants may break a lease if the landlord fails to maintain habitable conditions. Missouri recognizes an implied warranty of habitability. If the landlord fails to address serious health and safety issues after receiving written notice, the tenant may terminate based on constructive eviction. Kansas City has enacted local tenant protections, including source of income protections and criminal history screening restrictions, and these local provisions may affect how broken leases are processed within the city. Landlords in Kansas City should verify current local requirements. St. Louis has also been active in tenant protection discussions. From a practical standpoint, Missouri's rental market is concentrated in Kansas City and St. Louis. The Kansas City Metro, including the Missouri side communities of Independence, Lee's Summit, and Blue Springs, has steady demand with moderate re-rental times. St. Louis varies dramatically by neighborhood. The Central West End and Tower Grove re-rent quickly, while other areas take longer. Columbia's university-driven market has seasonal patterns. Springfield has a moderate market. Fort Leonard Wood area landlords experience constant military turnover. One best practice for landlords in Kansas City: understand how the city's local tenant protections interact with the breaking lease process. Build your procedures around the most restrictive requirements. Another best practice: document all mitigation efforts thoroughly. Missouri's case law-based mitigation duty means your documentation proves reasonableness. Missouri limits the security deposit to 2 months' rent. The deposit must be returned within 30 days. These rules apply to broken leases and normal move-outs alike. For the complete guide to Missouri breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.